Welcome to Swanson Reed's presentation on the recent Moreton Resources Limited and Industry Innovation and Science Australia decision handed down by the Administrative Appeals Tribunal of Australia in July 2022. This high-profile case involved the determination of whether a company's registered activities were eligible under the R&D tax incentive. This presentation has been based on the published AAT case description, which can be found on the Australasian Legal Information Institute website, and the Oz Industry commentary of the AAT decision, which can be found on the Oz Industry website. In addition, Swanson Reed has published some commentary on the matter, which is available on our website. The links to these can be found in the video description. The Moreton Resources matter is one of the most widely publicised cases since the R&D tax incentive commenced in the 2012 financial year. Over the past decade, a number of R&D tax disputes have been heard by the courts, and most decisions seem to find in favour of the regulators, in that many large disputed claims were not eligible under the R&D tax legislation. The original federal court decision in 2019 regarding Moreton Resources, which we'll discuss in detail later, was big news at the time, since it represented one of the few matters where a decision was ruled even partially in favour of a taxpayer. A preceding AAT decision in 2018 had determined that R&D activities registered by Moreton Resources were not R&D activities in accordance with the legislation. However, in 2019, the federal court set aside the AAT's 2018 decision and noted that, in the federal court's view, the AAT erred in its construction of the legislative definition of core R&D activities. The federal court remitted the matter back to the AAT in 2019, and the AAT decision that was subsequently handed down in 2022 is the focus of this presentation. We will start with some background information, followed by the case itself, and then the responses and key learnings from this ruling. The case centres around a resources project located near Kingaroy in Queensland. In 2006, Moreton Resources proposed the development of an underground coal gasification UCG facility. In 2010, Moreton Resources registered multiple core R&D activities under the R&D tax incentive scheme relating to the design, development, and operation of an experimental UCG pilot plant to test the viability of UCG technology. In March 2010, the pilot plant failed, resulting in underground water contamination at the site. This led to the Queensland Government issuing an environmental protection order, which initially forced Moreton Resources to shut the project down. Later, in July 2011, the government amended the order to limit Moreton's activities at the site to decommissioning, rehabilitation, care, and maintenance. The R&D activities Moreton Resources registered as part of their 2012, 13 and 14-year claims are the focus of the AAT decision. Specifically, core R&D activity in Kingaroy on the design, development and experimentation with UCG processes within a pilot plant, core activity in Wandoan on the development of the UCG process, and supporting R&D activities related to project maintenance, management and administration for both core activities. In 2015, Industry Innovation and Science Australia, or IISA, advised Moreton Resources that it would begin assessment of these activities to determine if they could be considered R&D as defined by the Income Tax Assessment Act 1997. Following the examination, IISA disputed eligibility and issued a finding noting that the company had not sufficiently demonstrated that its registered activities were core or supporting activities. The dispute was subsequently taken to the AAT. In September 2018, the AAT agreed with IISA's finding, noting that, firstly, the pilot UCG project was not deemed to be undertaken for the primary purpose of generating new knowledge, as it was not related to further developing UCG technology itself, nor any new form of pilot plant, device or process, and no work was considered as directly improving or altering existing UCG technology at the site. Secondly, there were no unknown technical outcomes, as Moreton Resources documentation explained the known technology of the UCG process, meaning that the requirements of the UCG process and variables were known, and risks such as rock shear causing casing shear were also known. Therefore, Moreton Resources' work for the project as a whole was not considered to include experimental activities, and thus the supporting activities were not valid because none of the activities claimed as supporting could be directly related to a core activity, as there were no eligible core activities. Following this, the matter was then appealed by Moreton Resources to the Federal Court. In July 2019, the Federal Court handed down a judgment setting aside the AAT's 2018 decision and noted that the AAT erred in its construction of the legislative definition of core R&D activities contained in Section 355-25 of the Income Tax Assessment Act 1997. The Federal Court noted that whilst Moreton Resources had been successful in the overall outcome of the appeal, it would be inappropriate for the Federal Court to determine whether the registered core R&D activities for the 2012 through to 14 years instead constituted supporting R&D activities, and the matter was remitted to the AAT for determination according to law. When the matter was heard by the AAT for the second time around, in 2022, the key issues for determination were 1. What core R&D activities were registered and conducted by Moreton Resources in the 2010 year? 2. Which of the core R&D activities registered by Moreton Resources in the 2012, 13 and 14 years were instead supporting R&D activities? Noting that some activities registered as core R&D activities in those years could no longer be contended to be supporting activities, as they were either abandoned by Moreton Resources during the full court appeal, or the scope of the remittal did not extend to these activities. 3. Which, if any, of the activities identified in answer to question 2 were directly related to or undertaken for the dominant purpose of supporting the core R&D activities registered and conducted in 2010? 4. Which, if any, of the activities registered in the 2012 through to 14 years as supporting R&D activities were conducted in the 2012 through to 14 years? And finally, 5. Which, if any, of the activities identified in answer to question 4 were supporting R&D activities registered and conducted in the 2012 through to 2014 years in relation to the core R&D activities registered and conducted in the 2010 year? The AAT considered what evidence could be accepted, applicability of the core R&D activity exclusions in Section 355-25, the purpose for which activities were conducted, and the relations and proximity between core and supporting R&D activities. The AAT handed down its decision in September 2022 and publicly released that decision in November. The AAT found that, except for 3 activities, Moreton's activities in the 2012 through to 2014 years constituted supporting R&D activities, in that they were activities related to and undertaken for the purpose of supporting core R&D activities conducted in the 2010 year. Key extracts from the decision included: given that the disputed activities all had a direct relationship with the pilot project and had no connection with other activities that could be pointed to, the correct conclusion to reach is that the dominant purpose of those activities was the relationship to and with the pilot project. The statutory obligation informed the manner in which the environmental testing, monitoring, and rehabilitation activities would be carried out, but that does not alter the relevant connection with the project in a way that disqualifies those activities from being supporting R&D activities. The disputed 2010 year registered activity, namely testing and evaluation of gas production and plant performance to ensure environmental standards are met, went to the heart of the experimental activities, as they were conducted to establish whether the UCG process could be conducted at the Kingaroy site in an environmentally safe manner. Without testing, it would be impossible to know the answer to that question. In that sense, the disputed 2010 year activity goes to the core or the heart of the experimental activities and ought not to be excluded under Section 355-25. All testing to determine whether environmental standards were met, and all other activities conducted in the 2012 through to 14 years were directly linked to the activities which were both conducted and accepted as core R&D activities in the 2010 year. As a consequence, whether the disputed elements of the 2010 year registered activities was a core R&D activity or a supporting R&D activity does not impact the substantive dispute between the parties. The Department, on behalf of Industry, Innovation and Science Australia, responded to this decision in late December 2022, stating that they will take the decision into account when assessing whether activities are supporting R&D activities, particularly in relation to activities conducted after failed core R&D activities. They also noted that activities may be directly related to core R&D activities if evidence shows the activities are an inherent part of the core R&D activities from the outset and there are no other parallel commercial activities. This case is a positive outcome for companies, particularly in respect of assessing the extent of directly related supporting R&D activities conducted over several years. As the dispute over this case spanned many years and would have been costly, it highlights the importance of documenting and assessing activities in accordance with program regulator guidance to minimise the likelihood of ending up in a costly dispute with regulators. IISA noted in their response, "Your circumstances may appear similar to this case, but you must assess your activities against the legal requirements based on your specific circumstances." That concludes this presentation on the recent AAT case of Moreton Resources Limited and Industry, Innovation and Science Australia. Should you have any questions, please feel free to get in touch with our office. There is also additional material on recent cases and R&D legislation and guidance available on our website. Thank you.